Hi, it's Judith Browse. We're back for another edition, actually a part two edition of the Author You, Your Guide to Book Publishing podcast. I love the conversation I had with last week's guest, Colin O'Brien, who is an IP, trademark, all those kind of umbrella things that come under protecting your assets, your intellectual property attorney. But let's reintroduce Colin. He is a partner with the firm of Latimer, LeVay, and Theoc. So I'm going to spell this for you. Latimer, Levay, Fyock. Better yet is to know the abbreviation for the firm based in Chicago, Illinois, would be LLFlegal.com. Just to protect yourself here. So a little bit about Colin. Colin is he is a co-chair of the firm's intellectual property group. So this is where he but spends all of his time. He's got an inherent appreciation of the value and the importance of your intangible assets. So that could be patents, it could be trademarks, be any data that's floating around. Basically,
Yep.
I want you to think about your imagination and what it creates. And the imagination is really the right word we're going to do. So we're going to do a dive into things like fair usage and all those other things that come along with it. But the quote I like to come up with, and I just randomly open this up to my book each day, the Snappy, Sassy, Salty, and just kind of say, okay, so what just sings it be? And I'm just going to say this: write what you want to write, not what you think will sell. Readers will know you are faking it. And a lot of times, I'm been in enough bookstores. I've spent all day the previous Sunday in a bookstore selling just selling my own books and just chit-chatting with people. And we had some great conversations and coming along. And one actually came up with he's so distressed with what's going on globally that he went to pick he was showing a book he bought. It was a beautiful rendition of Aesop's fables and what he planned on doing with it. So we're going to get into that a little bit. So what can you do with other people's works too? That's what's called public domain.
Yes.
And with that, Colin, welcome back.
Hi, Joe. It's great to see you. I hope you had a great weekend, and I'm looking forward to
Yeah,
continuing this conversation. It's very, very interesting, and it's I said in the introduction, this is a goal
yeah,
for like authors to kind of think about their intangible assets, think about what they can do,
yeah,
can't do, and ultimately what potentially what they can leave their legacy to their families as a
yeah.
result of all their hard work and their creative
Well,
work.
and I think you and I talked about some things we wanted to kiss on. So since you said the legacy for the families, I think that that's really an important thing to look at. And maybe I don't want to leave this hour without talking about how do you deal with that legacy? Who are you going to leave it to?
Right.
You know, you've got the
Yeah.
legacy. Okay, so this reputation's out there. Now we've
Yeah.
got these assets that you built it on. Have you thought about? Are you just going to let it kind of fade into the universe, which is a choice? It's a choice.
Right.
Or are you going to direct it? I mean, have you built up enough of a stock that maybe there's a library or maybe there's a type of museum in your community, especially for those of you who who have some stature there, that maybe they'd like to have all your stuff.
Right.
Um,
Right. Yeah.
so
And
how,
yeah, I think that's a really, really important kind of thing to consider. The interesting thing about a copyright is the copyright lasts the lifetime of the copyright creator plus
Mhm.
70 years. So that's a long time. And so if you view that as an asset, and if when people pass away, you give out your house, your all your other money
Yeah.
that gets assigned to somebody. You go through
Mhm.
probate or you go through a will. Your copyrighted works are another asset that should be kind of considered as a part of your estate. And you know, our firm, we have these brilliant people who do estate law. They're CPAs, they're MBAs, they're tax people. They kind of know it. And it's one of those things, uh as a
Mhm.
writer, if you're especially if you're a successful writer, you want to kind of talk to an estate attorney about, hey, I have this additional asset, this asset that will live on 70 years past my death. That could be helping your great grandchildren. If if somehow it gets a movie made of or something like this, you want to make sure that's protected and there's like recorded. And so if you're an author and you've had published books, you'll want to talk to an estate, a trust and estate attorney about like, hey, there's something else I have here, and can you
Mhm.
help me create a situation where I can be protected? Like you said, some people might say, well, you know what I want to do? I want to put it into the museum. I want to provide all my works to the museum and as a
Yep.
trust, and then they get the profit. If some
Mhm.
say a movie studio comes along and say, well, we would like to make a movie about this book, well, then that museum could get a benefit, or you could say, look, I'm going to create a trust for my family, and that's going to get in there, and like any sales continue, it will continue on. So it's one of those where, as a part of getting older and thinking about passing on, you should talk
Yeah.
to you should talk to people about this. And it's one of those. Um, so my entire career, for about the first 20 years of my career, I was only in intellectual property law firms, and now I'm in a
Mhm.
general firm. Now I see these people who do the estate stuff, and I was like, the best value of anybody can have in your life is just go talk to the state attorney. They know their stuff and they can help you guide through things. But knowing that your work will live on for 70 years in the law, that's a past your death.
Long time.
Yeah,
A long
that's a
time.
long time. And and you can kind of think about it too. It's like, how long things last. We kind of veers into the public domain that we were kind of thinking about. So remember Winnie the Pooh, the movie Winnie the Pooh?
Absolutely. And it just went into
To the
public
public domain.
domain last year.
Yes.
Last year? Yeah.
Yeah, last year. And so like, we all, everybody in the pictures, like it's cute Winnie the Pooh and the orange and the red pants. And then it went in the public domain. And then all of a sudden there was a horror movie with Winnie the Pooh where Winnie the Pooh was, going off killing everybody. And people might be like, well, that's weird. Well, why is this movie that's so beloved by people now all of a sudden other people can make different movies? Well, uh, it's an endpoint. There's an endpoint to the copyright protection. And so then people now can kind of, there's kind of the expression of an idea. And so this idea was protected for Walt Disney World Company for a long time, but then it goes in the public domain, and then that means other people can kind of do something similar. They can do, it's not exact, but like you an expression of an idea. And I think there's situations where ancient films or ancient stories, because Christopher Nolan is coming out with the Odyssey,
Hmm.
a movie of the Odyssey, and the Odyssey, what is it, 3,000 years old? And so he,
At least.
at least, right? So
Yeah.
he's creating a new story. He's reimagining a story that's been around for 3,000 years, and that movie's gonna come out, and he's gonna have a copyright in that because that was his creation of that old story.
So, you just really trigger a really important thing here that when this comes out again, now we have a new copyright running under with another name
Yeah,
involved,
yeah,
that can go on now for the lifetime of that person plus 70
70
years.
years.
I got
Yeah,
that right. Okay.
yeah,
So I think that a lot of us, I would probably put myself in that boat. We don't think that far out with what our imagination
yeah,
um,
yeah.
brings along.
It's
Or
yeah,
now we've got reimagination going on.
right. And the interesting thing is, the Christopher Nolan comes out with the Odyssey.
Mhm.
You and I can say, hey, let's make our own movie. We can make an Odyssey. It'll be you and I, our imagination of the
Ooh.
Odyssey, and it's our own creative work. And then that goes on for the plus 70 years. But it's as long as we're not copying the expression of the idea that Christopher Nolan, you know, the idea of like, okay, there's a man on a journey. He comes back from war. He wants to get home. That's the idea, right? And most stories have the similar ideas, and the expression of those ideas create the copyrighted work.
I think that you triggered something that a lot of times that I think about. with authors. I mean, I experience it with authors, or sometimes I had it on the third Friday of every month. For example, I have a thing that's called Ask Judith that people can call in and put
Hmm.
it out.
Yep.
I'm open. You can pick my brain. You pick my
Yeah.
brain
Yep.
online. And this someone who I did not know at all, but she was saying I'm looking over a contract and signing with a traditional publisher. Didn't she would not, she was fearful to say who it was. She
Okay.
was absolutely paranoid, and this is where I'm going here, to even say what it was about. And her title and all that. And I'm going through part of some of our conversations from last go around, last week, is that you can't copyright your title. But what you revealed about doing with series, I can't tell you how many times I put that out to my coaching groups.
Yes. Create a
About,
series. Yeah.
yep,
And
yep.
it's
And
and
I told,
yeah.
and I told them all, make sure you look up Stephen King and
And all his
trademarks.
trademark registrations he has under his name, right? It's kind of he's basically he's the ideal for authors because he's a great writer. He's had movies made of his works, and he also
Mm,
has made sure that his name is protected, and he's created a line of products based on his name. And
that's right.
he's perfection when if you think about it from IP standpoint point of what he's done with his name, with his books and everything like and his creative output. And you can never go if you never go wrong by looking at the best and seeing how they did it and kind of considering ways you could do it yourself.
Yeah. Well, and that's where I was just thinking there's so many things that authors could do where they can't trademark, or maybe they don't want to spend the money trademark, but coming in with their name or their series and then have them all this stuff catapult underneath it is huge.
Yeah, and it's one of those, you don't ideally you want to get the federal trademark protection, but like you can just put a small TM next to your product, your name,
Mhm.
because so there's two different things. You see the circle R,
Oh, that's a
and
oh, let's talk about that
yeah,
because
yeah,
yeah, because that TM is a warning, 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 kind of.
yeah. Yeah.
All right.
The TM is a notice. You're putting people on notice that you're claiming trademark rights in this term this name. Uh, and so if even if you don't have a federal trademark registration, you can assert what is called common law rights because
Hmm.
we're based on the English common law. And so like you're putting people on notice that like yes, I'm asserting trademark rights in this for these goods and services. Uh, if you apply for an application with the United States Patent and Trademark Office and you get a registration certificate, then you use the Circle R. And the Circle R puts people on notice that the federal government has essentially granted you a monopoly for that term for those services nationwide. And why is that so valuable? Well, one, it's you just created like an asset that it's recordable. You can go to the patent trademark office like there's your name. It's like you have these trademark registrations. That's really important because if somebody wants to get a loan or something like that, and like, well, what's the collateral? I'm like, oh, I have trademark registrations. I have the inherent goodwill associated with my marks, and there's a function with the registrations, and it also if somebody starts infringing on your work, you can call up me and I send a really nasty letter to them and say, like, you better stop. And because like we have a federal registration, you're not supposed to do this. And it oftentimes the letter solves the problem. Whereas if you have a TM, they could be like, yeah, you don't really have all the protection. But it's a valuable thing to have. I mean, everything's cost. You probably rule of thumb like $3,000 for a federal registration, like from soup to nuts.
to get to get all the bases covered. Uh,
Yeah, yeah.
so I can't imagine Stephen King's bill.
Well, if you imagine his bill, but he's probably run the numbers and it's like, well, this is making me lots and lots of money.
Oh, he has made lots and lots of money.
Yeah, yeah.
Oh,
And
all
and
right.
and what he probably does is he puts his name on the products, and so he licenses it. And so he's licensing. He said, like, okay, I'm going to put my name on these calendars or something like that. He's like, but I'm going to say I'm going to assure the quality is up to my standard. So he's licensing it. He's saying like, okay, I let this
Hmm.
company use my name because I approve of them and the quality meets my expectations. And so that's called a
Hmm.
license. And that's one of those
Well,
things.
licensing, yeah, you talk about monetizing. Oh,
Yeah,
oh, you know what? When we kissed on and we talked about Elvis Presley, what, has been done after all his songs were stolen by the
yeah, yeah,
Colonel Parker? Um, but what they have done with from the imaging, from his, the mic holding, from his hair even style to the white suit that he wore at the Hilton Hotel in
yeah,
Vegas. I
yeah.
mean,
I mean, they've really done a brilliant job of protecting his likeness and his image, and then they also do a good job. They don't put it on chintzy stuff. They don't put it on low quality stuff. And it's another
mhm.
example who does that, the estate of the Marilyn Monroe. They also, there's a Marilyn Monroe wine, and they use the
Mhm.
image of her, and so that's the Marilyn Monroe estate. And so, but they're like, they're assuring people that the quality is good and it's proper, and then that they approve of the use of the image.
Yeah. Well, it's an amazing thing. Okay, so we've got I think it's important to really understand for all of you authors out there, if you're starting on this path, I mean, maybe you should start doing the TM.
Yeah,
Put
you can do
put
it.
out
Just
your put your
yeah,
warning shot out.
yeah,
This is me. This is where and you do it on everything where that
yeah.
shows
Well,
up.
if you're using the mark, yeah, put it on everything. The marketer people will always say, "Oh, I hate how it looks." It's like, well, it's more. This is where the lawyers will come in and say, "Well, but at least you want to assert it, because if you're just putting it out there, people like, well, I didn't think it was a trademark." You know, you don't want people to be claiming ignorance when you can say like you're out there, the notice is out there.
Okay, so I do have a question. When I know when I'm doing writing and I've referenced products. Now this was my understanding, my belief. I could be so wrong here. But when I've used well, for example, I have a kind of a fun relationship with Costco. So
Yep.
that's a registered trademark. And my understanding was if I show that R, because it can be visually offensive if you see it every time the word Costco is, or every time you see the word General Motors, or
Yeah.
any other.
So you mean in a book?
Yep. Okay. It
Um,
was my understanding if you do it once, it's implied throughout. You don't have to keep doing it every time the name is
yeah,
used.
yeah.
Am I wrong on
You don't
that?
have to. No, you can do it that way. One thing you can do
Oh,
is put it in capital letters. So it's saying this is a trademark. So if you're writing and like normal fonts and then Costco in capital letters, but like this is you're not really you're making it a part of the life of a story, and you can write in the beginning. It's like, there's the following trademarks are mentioned in my story, but they don't imply an endorsement or anything. It's just
okay.
they're the property of the trademark owners, and I'm not there's
Right.
no endorsement implied.
Should an author also state if they're using that on there for like a disclaimer on the copyright page in their book?
I think if they're just using this as a way to kind of describe their story, it's like it's kind of um, if the story involves a mother and daughter and they're going to go see a concert by a woman who's married to a football player who plays for the Kansas City Chiefs, you're going to use the name Taylor Swift, right? Because it's like, yeah, the mother and daughter will go to the Taylor Swift concert. So Taylor Swift might have a trademark in her name, Taylor Swift, but you're not. You can say like the Taylor Swift trademark is just it's a fair use of the Taylor Swift trademark because you're using it as a part of your writing. It's not you're not writing the Taylor Swift story.
Okay, so let's talk about fair use. All
Yeah,
right.
yeah,
You,
that's kind of
you,
where we're kind of
okay,
tiptoeing around, and
we're tiptoeing around. Let's get into it.
yeah,
Um,
so
it- so what is it?
yeah,
Um, how, when does it work? When does it not work? When it, I think there is a lot of confusion on fair use.
there's always confusion, and there's very
Yeah.
smart people sometimes make a mistake, and there can and there's one thing, there's a lot of gray in fair use. But what it is, it's a legal doctrine that promotes the freedom of expression by permitting the unlicensed use of a copyrighted protected work in certain circumstances.
Okay.
Okay, so that's kind of so it means you can use copyrighted work, but in trademarked work in a certain text. So the first thing is like, are you using it in a commercial manner? And I think that's kind of, that's an important thing. It's, so if you're kind of using a copyrighted work as a creative crutch to kind of sell your own work, uh, that won't be viewed as fair use. And
That
uh,
sounds fuzzy to me.
yeah, it sounds fuzzy, but it's one of those. There was a case when OJ trial was going on.
Mhm.
There was somebody who did a he said it was like a version of Judge Ito, but it was done through in the same format as Dr. Seuss, as the Cat in the Hat, but it was kind of
Right,
they were
right.
doing it as
I
Judge Ito.
remember that. Actually, I
Right.
remember that.
Famous case, and the Dr. Seuss family, which he had passed away, but the rights on his works were still there. They sued, and what the judge was like looked through, and he says like, one, it's not a parody. We'll talk about parody later. And two, you're not really you're using Dr. Seuss's prior work as a creative crutch to create something new. You aren't commenting on the Dr. Seuss work. You're using his work to make money yourself. And so that's not fair use. That's a creative crutch. It's like you weren't creative enough to do something on your own. You copied another author's work. You kind of did his whole the way he wrote, the way he illustrated his books, and you copied it. And you it wasn't and you copied it for money. And so the Dr. Seuss estate won, and that book was taken off the shelves. And the person might say, no matter how, even if it's funny, just because it's funny doesn't mean it's legal. This is kind of a funny idea, right? But you didn't
Mhm.
have to copy the works of another author. You're like, I came up with a funny idea, but I wasn't creative enough to come up with my own illustrations or way of writing, so I just copied. I used it as a crutch. I used somebody else's prior work, and that's improper. And so,
So, so let me ask, now I'm going to throw in an AI thing. If I went into an AI deal, and this since we'll stick with the OJ or the Judge Ito deal,
yeah,
um, which wasn't around during this whole
yeah, yeah,
that if I put in the prompt to create a parody, blah blah blah, in the form of Dr. Zeus, and specifically around the way green eggs and ham was written.
yeah,
I'm I'm just
yeah,
throwing stuff out.
yeah.
Uh, and then it comes back, and all of a sudden you have the I ams, and you have all kinds of little stuff. You're going to get in trouble, would I assume?
This is why they're getting sued because I think
Yeah,
that idea of this generative AI, where it's like, well, I put all these prompts in, and then I got this
yeah.
response. Like, well, one, where did you get all of that language from? It's like, oh, you actually literally copied all of his books and you put them into the
They
machine,
did, and they
and
did.
and they did, and it's and it's one of those also where the Copyright Office has still insisted that anything created through AI prompts is not copyrightable.
Right. And
So
that's really an important thing to say, Colin. If whatever you put in as your prompt and whatever the outcome is not copyrightable.
yeah, like the
People,
final outcome is not copyrightable, and there's it started with a case a couple of years ago, and somebody
yeah,
they did a fascinating piece of artwork. It was he said he put like thousands of prompts to kind of get what he wanted, and his argument was like the copyright of it should have been all my prompts to kind of get that. But the copyright office is like, no, that's still not appropriate. And I think you know it's frustrating because like say you're Dr. Seuss estate, and so like you somebody goes in there and make me a parody of Sam, do something to Sam I Am, and a different subject and the whole, but like if you're going to, how do you sell that? So this is a good thing. It's like, okay, you do that. Well, if you go to a book publisher, the book publisher is like, well, do you have a copyright? It's like, no, I used it all on generative AI. And the book publisher is like, I don't know how to use this. Why, how can I sell it? Because you basically told me that you just kind of copied it from AI. And how are they going to, how are they going to sell it in a bookstore when they don't have any copyright protection? So it's one of those where I think the creatives will still have more control.
I'm curious. You mentioned one of my favorite words, bookstore. Um, if a bookstore, because I was asking some of the managers, saying, are you able to tell stuff that is generated from AI? And most of them said most of it's pretty boring on it, and they're turning it away. Could a bookstore have a liability of selling a book that is violated the copyright and generated it all off of Dr. Seuss or John Grisham or fill in the blank?
Well, I would, so that's a concept like contributory copyright infringement.
Mm.
And so if you're a bookstore, and there was a famous case out in California about a flea market, and basically the flea market was selling counterfeit goods the whole time, right?
Whoa. Okay.
And then the counterfeit, the trademark owners will go in and sue and get the sellers because the sellers and the stalls are selling the counterfeit. And after a certain point in time, they sued the flea market because they said, look, you know that this is counterfeit, you know what's going on, so you're contributing to the infringement. But if you're a bookstore and you have relationships with people and say, here's my book, I'm the author, and it
Mhm.
goes in and you start selling it, and then you receive a letter saying, hey, this is copyright infringing. The bookstore is just going to take it down. But
Mm.
if there's lots of, it's kind of the situations. Like if the bookstore sells lots and lots of copyrighted and infringing products, well then the copyright owner will probably say, hey, let's sue the bookstore. It's kind of what we talked about before about the websites, where like if you understand something is infringing, you just take it off. If you're a bookstore, you understand something is infringing, you just take it off the book because
Mhm.
you've been put on notice. This is go back to legally. You're put on notice that this work is infringing. So if you know it's infringing or there's an accusation of infringing, take it down. Until the author or whomever comes back and say no, it's been adjudicated, it's proper, you can have it back up. But it's just
Well, there's actually something that got just canceled. A major publisher started getting suspicious and all that, and they removed the publication of one of their lead books.
oh wow. Well, what was the story behind that? That's kind of fascinating.
Well, now I'm gonna have to go back into research, but I
Yeah,
said good for them
yeah,
on that. So that's the pushback that I want to see happening
yeah.
uh, on that because, as I've said, since COVID, I think a lot of people have gotten lazy and shortcutting things like crazy, and this is one of the shortcuts.
Yeah,
Hi.
and but the one thing good thing that I think people should because we can't be Luddites about AI because it's going to be here. And this is what I said like the
It's
last
here.
episode.
Mm.
Writers can use AI. It can be very helpful for them, particularly if you get it like I said, make sure that it's not anything that you're using is in a closed system. So it'll start recognizing your writing and so you can get a sense of, you know, like am I using the right tense throughout my novel or something like that. So it can be an assistant for you. But it's not writing it for you. It's kind of that there's a difference. It's at a certain time you have to realize that it is a tool. Um,
Hmm.
but it's if you use it as a tool to help you write better, that could be very helpful. It could be an editorial assistant. And you could if you're writing a historical novel and you have 200 pages and you're like, well, how can the AI help me? It's like if you have it in this closed system, it's like, can you confirm the dates are all matching up? Because sometimes in historical stories where like it's 1374 and then it's 1363 and then you're kind of because
You're, you're
you're having
you're
this
looking for
yeah.
Yeah, you're looking for consistency, and I know since I'm working on with my writing partner for fiction, the fourth book in the series. and I just so dislike this one character. I just so, and it's really good to have an antagonist that everyone gets pissed off. But
Yeah, yeah,
I just said to Brian, listen, I want to whack him. I've just had it. I want to
yeah,
whack.
yeah, yeah, yeah.
And this person was a real character. I mean, a real person back in the 11th century.
Okay,
And he said, but he's really, he really didn't die this way. I said, look at this is a fiction book. Why can't we kill him?
right, right.
And I said, it's our now we're going back to the imagination word. It's our imagination, or at
It's
least
your imagination. Yeah.
I'll claim the trigger. And it's like we had a bad character, and people by in book two they said, when are you going to take him out? And I
Oh,
said,
yeah.
it happens in book three.
Yeah, isn't that great? And then
Yeah.
that's the cool thing about it. And so it's just as a starting off point, or even a situation where if in book one you describe the character as like, okay, the character is 6'3", has red hair and green eyes, and then maybe while you were writing book three, you forgot that he has like it has dark golden hair or something like that, and then you realize, oh, it's a little bit of an inconsistency because you're so busy in writing everything. That's something where if you have your closed AI, can be really helpful for you to
Hmm.
kind of
I
say,
think so.
am I being consistent with my description, like Julie's description of this character
Yep.
throughout, and that will kind of it'll allow you to kind of like, okay, I've been consistent, or like, and then it's like, oh no, you're actually being inconsistent, and then you look at it, it's like, oh well, that actually sort of makes sense because people's hair changes, and you can kind of think about like, well, why did they change? So why did my in my brain, my imagination, did I change him from looking like this to 12 years later in the book, he's looking like this. And then it gives you, that'll give you another jumping off point. It's like, well, I should kind of add some like a background about, oh, okay, let's kind of talk about that. Like, why did his image change? And it could be just a mistake, or it could be like, oh, okay, I've changed my view of the character, like you just said. Like he was
Mhm.
a character. It's like, oh God, I can't stand him.
Oh, it's
Yeah,
just evil, evil, evil. All right, so let me loop back. Let's get into the
yeah,
fair usage. Come back to
yeah,
go. So there's got to be some parameters of what an author can do for fair usage. There's got to be some, I guess, rules that they should
yeah,
know about. And
yeah.
so, can you kiss on some of those?
Yeah, so we'll do like there's four main rules.
Okay, there.
The
That's what. Let's get into those.
Yeah, okay. The first one, do you want me to go to the four rules and then we can go
Sure,
back and
let's
discuss them?
do
Yeah,
that.
okay.
Yeah,
Yeah,
let's do
okay.
that.
Okay. So the first one we kind of talk about is the purpose and character of the use, including whether the use is commercial nature or for nonprofit educational purposes. The second one is the nature of the copyrighted work. Um, the third measure is the amount of substantiality of the portion used in relation to the copyright work as a whole. So this is kind of like, we'll kind of talk about that. And then the fourth one is kind of important, the effect of the use upon the potential market or value for the copyrighted work.
Okay.
Yeah, and I think why don't we go back and kind of view this through the filter of like the AI companies taking all the copyrighted work. Because as we said in our prior podcast, they're like, oh, they're claiming fair use, they're claiming fair use, right? And so let's say the purpose and character of the use, including whether it's for commercial nature or nonprofit educational purposes. So I think we mentioned before, when OpenAI started, they were a nonprofit organization, and the thing was like, we are going to help people, right? That was the whole purpose. It's for the good of humanity that we're gathering up all this information. Because they must have said like, well, if we say we're a nonprofit organization, then maybe we have more of a fair use defense because we're taking this information. Now they're a private company, like getting paid, hundreds of millions of dollars and not billions of dollars by people. So their nonprofit idea has gone out the door. And it's now they're saying it's like, well, we've transformed the work. So if output generative AI output doesn't create a copyrighted work, I don't see how you've transformed the work because you haven't created anything new. You're just taking
Mm,
somebody's work. This
mm.
is, there's brilliant people discussing this back and forth, but it, you're taking somebody's work and you say the output will be transformative, but that transformative work is not copyrightable So then that just means you're just taking people's work. And
So you're ripping them off.
uh, it doesn't strike me as being a very fair use under that. Um, and then there's the nature of the copyrighted, and that's kind of a little bit different. Okay, so um, so if there's well, let's so you offer career coaching advice too, right?
I do. And and I can add to you, give you an example. There was a really well known, if I showed some of the cartoons that I'd used, you would instantly recognize the creator of it.
Mm-hmm.
And I had written to Gary and I was speaking in that and I wanted to use I had these certain points I was
Mm-hmm.
using in a presentation. And I was getting paid usually
Yep.
for these. So there was enumeration to me. And I said, this is so perfect for me to make, for example, this cartoon making his point. And I got permission from him to use them. What I told him that because I always gave handouts, I would never include any of his cartoons in my handouts. I would never do it. I just wanted to show it up on a slide to make
Mm-hmm.
a point. And it was done for because some of my talks, when I was dealing with toxic workplaces, got
Mm-hmm.
dicey. I needed that relief button to help
Yeah.
get it through and do the transition. And it was very effective, but I was
But you also
always,
did the right thing. You recognized that he had a copyright in his work,
I
and you
did.
were gonna, and you reached out to him and said, "May I please use this?" He
Yes.
could have said no, and
Yep.
if he had said no, it's like, okay, thank you very much.
Yep.
But you
Yep.
know,
And I did, the music thing was another thing. I did that with Merv Griffin
hmm
because in my book, The Confidence Factor, and I was doing all these stages stuff, and it was like crazy that what I did with that. And I asked him if I could um, have the setup, the music from Jeopardy to use.
oh, okay,
And he wrote back and he said, "You have permission to use it."
that's great. That's fantastic.
Yeah.
But
So,
but you did the right thing. And but there's other things where like there's licensing groups. So like if you ever wanted to use a Madonna song in anything,
uh,
you better get a license because she'll charge like $50,000 for 15 seconds of her time. And and this is interesting because if we go back to kind of the idea of the Gary Larson picture,
mhm,
um, you know, if you were offering a seminar
mhm,
on uh, cartoons or comic writing and comic style,
mhm.
and you say, okay, let's look at this one that he created, and then you discussed it. And like, okay, this is how I view this is why this is funny. It's funny because of this, and then the added characters. You
Mhm.
actually that would be fair use
Yep.
because what are you doing? You're writing a seminar. You're providing a seminar on for potential cartoonists and what works, what doesn't. In order to do that, you have to provide some actual work so people can comment and criticize and understand. So you could that would fall under fair use. I would view that as falling under fair use. But if
Mm.
you're offering a seminar on workplace harassment and you see something from Gary and he put it up there, well he would say, well, unless I did, if I gave you permission, fine. But if there was a different cartoonist, they would say, well, you can't use my work for that because you're using it for a different purpose. So
Mhm.
it's tricky, right? It's kind of
It's tricky. It is
yeah.
very, very, and it is confusing
It's
for
confusing,
people
and
with
it's
this
it's one
fair
of those
usage thing.
when in doubt, just kind of talk to somebody, talk to an attorney, go through and kind of figure it out.
Mhm.
Because um, the copyright owners and the copyright society, and they're called troll attorneys, troll lawyers,
Troll attorneys.
trolls. They you know, copyright damages are based on statutory damages, so you actually have a set number. And so what there's some law firms that'll go out there, they'll just send letters to everybody and demand payments. and they just get paid whatever as a percentage of whatever the infringer pays. So you have to be careful, like, and there's the situations like, a lot of
So
times.
is that would that be almost considered from the troll attorneys a scam? Are they just throwing stuff
No,
out
no,
to
no.
see
It's
if it
it's perfect.
scares
It's
you?
perfect. It's perfectly legal. It's like they're representing a copyright holder,
Oh,
and
they are actually
they
have
are
a
representing.
relationship. Right.
Yeah, but what
They're not
they're
making
doing
it
is
up.
they're scouring the internet for anything that uses pictures or anything like that. And this is another thing. So, I would imagine a lot of your listeners have blog posts and
Yeah.
or online media.
They use so much stuff in there. Even though they say they give the credit to the source, I'm just did they really verify if there was a cost to using it?
Yeah, and there's this is where people are sneaky because sometimes there's a concept called Creative Commons where you can use an image, but some of them they use a fake like Creative Commons thing, and a company or a blogger will post the picture on there, and then they get the nasty letter. Um, you
Mhm.
know, if you have a large audience, and I would say a large audience is more than 5,000 like viewers of your web page.
Mhm.
Uh, go to an image service and have that rather than kind of copying images off of your off the Creative Commons or anything like that, because the risk is immense. Because what if you have 10 images and then they say like, okay, each image is $10,000 because of statutory damages. It can ramp up really really quickly, and because the software is so advanced, they can just scrape everything every day to see if any images are being used.
So are there any particular names that you would recommend as an image service?
Well, Getty Images is always
Getty, yeah,
it's the creme de la creme.
the
And
creme de la
interesting,
creme.
Getty Images is suing the AI companies because they took all their images. And that case is,
Oh, absolutely. In fact, there's some well-known covers that have gone on that a major publisher really picked up, and they never had permission. So there's that's
yeah, yeah,
floating around in the
yeah,
publishing circles. But so you need, I think all of you need to be aware of that if you're using any images. Where sometimes when I'll get like I have a cookbook, and I mean I took all the pictures, and it was really a kick when Costco says, "So where did this picture came?" They asked me, "Where did this picture come from?" I said, "Well, I took
well,
it."
that's
So
why because they're worried about liability, right? Because
they
because
were,
because if Costco is selling 100,000
yeah,
one of your
yeah.
cookbooks, somebody's like, "Oh, that's my image. That's a
Mhm.
100,000 times you sold it. Like, I'm going to sue you for this much
Yeah.
because they're going to say, well, Costco as a giant corporation, you should have cleared everything and made sure everything was appropriate." And
Oh, they even sent me a check for it. He was like,
yeah,
"Whoa,
yeah. Well, they because that because when you're a big company like Costco, a
yeah."
little thing can blow up and be really really expensive, and that's an indication that you're working with a really really good company that is thorough like that and asks you these
Yeah,
questions.
they wanted to know that. So, I mean, there's for all of you, there are sources out there. I mean, and like what Colin is saying, Getty is huge, the creme de la creme.
Yeah,
But that you also, maybe you need an account with iStock, which has got all that
yeah. I
stuff.
saw another one. There. Just look at photo sharing, photo image services. You
Yeah.
get the account, and what that provides you is like peace of mind,
Yeah.
and you're
And
like,
and by the way, you want it. So when you're going online to these groups like Upwork and Fiverr and all
yeah,
that, and
yeah.
you go in and say, I need to have some drawings like this. I want, pen and ink, and I want this and kind of like that looks like this, and what can you do? And of course, the bots or individuals just mimic everything. But now you've got another problem, maybe because now I've learned a new term called the trolls, uh,
Yeah,
the
yeah,
licensed trolls.
yeah, and it's unfortunate because sometimes what happens too is like if you're an author or like a small business person and you're busy and like I'll get a young college student to kind of help me with this, and like they love marketing. Oh,
Oh,
let's go on
yes.
social media and they use it. Um, they mightn't understand what they're doing, just because it doesn't
It's,
affect them. Like there might be we'll
yeah,
make a reel and be really popular, and it's like, yeah, but are you copying the music, and like, are we allowed to use the music and stuff
no,
like that? So just be
no.
careful. Like, be careful about of enthusiastic college students helping you out with marketing, because they might necessarily understand the legal ramifications of it.
You can always find, it takes work, but you can find who owns the rights to these words. And I can remember one time, Colin, that I had one of my clients was wanting to use lyrics from the song Monday Monday by the Mamas and the Papas.
Hmm.
And I was able to track down the owner somewhere in the Midwest, Iowa, somewhere. And I actually, and when we did the chapter, that this is a guy who was in exile, and he kept thinking, Monday, Monday, it's gonna come, and my life will come back together, and Monday,
Hmm.
Monday. And it would just took over, it was like his mantra. And because we showed the way we wanted to use it, we had to pay. We had to pay, but it was a minor amount for $125 for
Hmm.
every 10,000 copies. I mean, it was very specific.
Was it
What
the whole song or just like a kind of a verse?
it was a couple of verses.
Hmm.
It was a couple of verses,
Yeah. I mean,
but they
it's
can't.
good that it didn't cost that much money, because you could almost argue that's fair
No.
use, because it encompasses the part of the story. But it's
Oh,
better to
it
get the
definitely encompasses story,
yeah,
but I've
yeah,
always told people if you're going on a song lyrics, get permission. Otherwise, don't use them. Period.
yeah,
You can
yeah,
you can use the title of the song. In this song,
yeah,
blah blah blah, it talks about, it forewarns, it does a deep dive into. You can do that, but that's safe. Otherwise, you're going to track it down and you're going to pay for the right.
yeah. And just be very this in general with like music and songs.
Hmm.
You know, so there's the lyrics of a song. There's
Yep.
the music to the song, like the notes. There's a
Mm.
public performance to the song as well. And so the reason why why is Madonna so wealthy? She wrote the lyrics, she
Yep.
wrote the music, she performed the songs. That's a triple threat right there. And those are three different copyrights she has in one work. And so that's why, like, if anybody ever wanted to use some of her work, it costs so much money, because it's all her creative output. And but then there's all the situations where there could be a song where the the lyrics are written by one person, the music was written by another person, and it was performed by a third person. And then if you use it, then you have potentially three plaintiffs going after you. So yeah, be very, very careful with music. Very careful with music. And I think this kind of goes back, going back into the fair use and the amount of
Yeah, but
substantiality of the portion used in
right.
the copyrighted work. Um,
Right.
so there's always the things like, oh, like a 30-second rule. Like, there's some people say, well, I can use only 30 seconds of a song or anything, like I'll be fine. No, you can't. And there has to be a small amount, and you have to talk about it. And the best example, remember Siskel and Ebert, right?
Right.
They would offer their movie critics
Reviews. Yeah,
reviews.
they're
And
reviews.
so you would watch Siskel and Ebert, and they would say, okay, we're talking about this movie, and then they would show like a short snippet
A clip.
of a
Mhm.
clip. They show a clip, and then what would they do? They would turn the clip off, and both of them would go back and forth and talk about it. So they did a small portion. Then it was they that after showing that small portion, they discussed it. But if you just decided to use a small portion of a clip just because you thought it was funny, and so like going back to your career coaching seminar, and say there's something really funny from a movie, like from 9 to 5. Remember with Dolly Parton
Dolly
and Jane
Parton.
Fonda, and
Hmm.
there was a scene there that you thought was really, really funny, and you showed that scene, and it's like, isn't that funny? It's like an icebreaker, and then he's like, well, let's talk about what we're talking about. That arguably is not fair use.
Hmm.
That's
I I used to, so let me do something I used to do. I used to vary. go into unbelievable detail describing a scene from a Seinfeld episode when
Okay.
I was talking
Yep.
about communications and miscommunications and not communications and screwed up communications. And I said, and I would tell people, go with me. Can you read, in a sign, and I would say in a Seinfeld episode, Jerry and Elaine are in the cafe. Kramer comes tripping in and sits down, and he has his girlfriend of the month. So I've set the stage and I start going in. And this was the one on the silent talker. Do you remember that one at all?
I think so. Yeah, yeah, yeah.
Okay. So Elaine asks her a question and she says, and I just mouth it. And Jerry and Elaine look at each other. I mean, I'm going back and forth. I
Yep.
am I am acting out the whole thing. And then Jerry starts nodding his head, and of course he's agreed to wear this puffy pirate shirt
Oh, the
on the
puffy shirt.
stage
Yeah.
show.
Okay. Yeah.
It's the puffy shirt episode. Okay. Everyone got it. We didn't need to show a video.
No, and that's
We
fine, right? You just kind of you're telling a story
Yeah, yeah,
about a show, and
yeah,
that is completely fine.
yeah.
It's good.
And I worked on that in my speaking. I worked on that to choreograph it, to
Right.
bring them in so they're all there. There was another, I remember I used to use an example from the movie The League of Their Own with Tom Hanks
No
and the
crying in
whole
baseball, right?
oh yeah, yeah, exactly. And that the audience is mouthing it with me.
Right. Right. And
So
but
much
because
safer.
that's incorporating culture, right? And that's fine. But
Yeah,
if you had a picture of Tom Hanks and his running out of the dugout and having an up on the screen, that wouldn't be appropriate.
no,
But
no.
yeah,
And I would say, picture this: Tom Hanks has now got his leg up. He is chomping
yep,
gum or
yep,
tobacco or whatever it is, and
yeah,
he is, and his outfielder is coming in, and he says, and the audience yells out, "There's no crying in baseball."
yeah.
Anyway, so I used to use stuff like that. I just found it was far more effective than
Right, right. Because you're actually
saying,
they're looking at you rather than looking at a screen and telling the
yeah,
story. So
exactly.
yeah,
Exactly.
yeah.
So anyway, that's what I was after in all of that, in putting it together, and it was really effective.
And
Uh,
it takes hard work. Going back to
oh
the
yeah,
idea of you could have used the creative crutch of just showing the videos, but you're
yeah,
not going to do that. You're going to like, okay, you recognize it, but you're going to use it on
yeah,
your own purpose. And
yeah.
it's if you're bringing people's memories to something, that's completely fair use. So,
Yes,
um,
yeah. So that is what I am at. That is what I was after.
yeah, yeah.
In
So
doing,
I know we're kind of running short of time, but I think
yeah,
what the ultimate thing is, fair use is available, but it's tricky. And if you're ever in doubt, you should kind of talk to an attorney about it, because you don't want to get yourself in the morass of a lawsuit or a nasty letter sent,
okay,
without at least somebody saying like, well, I talked to them and here's the opinion. It's like I'm okay.
okay. So Colin O'Brien, thank you so much. So we've talked about parody a little bit. Fair use is so important.
So
Think
important.
about
Yeah.
your estates. Think about, okay, so where do you want your legacy to go? And if you're looking for some ideas, go into the public domain and see what's out there. Maybe there's something you
Absolutely.
can run with
Yes,
that.
definitely.
All right.
Definitely.
All right, everyone. Have a great week. And we'll come back and revisit. Colin, we'll do this every once in a while. Just come back and see what's
Yeah,
new.
I think that's a really good idea, especially given
Well,
that like how the cases are progressing, and then like as
I
people,
know.
if your listeners have some questions, we can kind of talk in general terms about what's going on. And it was wonderful talking with you, and I appreciate the chance to speak with you about this really interesting subject. And I getting to help creatives is
All
really really
right.
satisfying.
Great. You can find Colin at llflegal.com. All right.
.com.
Take care,
Okay,
everyone.
okay, okay.
Okay.
Bye, Judith.
Bye-bye.